This is part 14 of the revision lecture series on arbitration. So in later videos, I'm going to discuss the disadvantages of litigation as compared to ADR processes and also the advantages of ADR processes, in particular arbitration. However, quite apart from the advantages and disadvantages that we're going to discuss later, it is very important to note at the outset that even though I mentioned in the previous video that arbitration can be seen as a private version of litigation, that does not mean that they are both one and the same thing. So, at the outset, you need to know how arbitration differs from litigation in two main areas. So the first major difference between these two, that is arbitration and litigation, is that a dispute will only be referred to arbitration if and only if that is the course agreed between the parties. So, like I mentioned earlier, arbitration has a contractual basis. And of course, this is not how it happens in a lawsuit. In fact, far from an agreement, there is no need absolutely for one party to seek permission or agreement from the other party before filing a suit against that party in a court of law. And the second difference between arbitration and litigation is that arbitrators are appointed by the parties themselves or through a mechanism that is again agreed by the parties, whereas in litigation, obviously, the judge is appointed by the state, so there is no choice of who is going to be the judge in your case. However, in this aspect, one point to remember is that arbitrators are also sometimes appointed by the court, so ultimately there may not be much of a choice. We'll talk more about this in detail in later videos.